The Supreme Court seemed poised Wednesday to uphold a Mississippi law that bars abortion after 15 weeks, but it is less clear if there is a clear majority to end the right to abortion nationwide, although conservative justices expressed skepticism about the landmark Roe and Wade decision. The dispute represents the culmination of a decades-long effort on the part of critics of the landmark opinion that legalized abortion nationwide to return the issue to the states, a move that would almost immediately eviscerate abortion rights in large swaths of the South and the Midwest. During sometimes tense and heated questioning in almost 2 hours of oral arguments, the court's 6 conservative justices signaled they are comfortable with the Mississippi law even though upholding it would be flatly odds with Roe and Wade, the 1973 decision that established a constitutional right to abortion and prohibited states from banning the procedure before fetal viability, currently around 23. Justice Brett Kavanaugh, appointed to the High Court by former President Donald Trump, suggested on numerous occasions that abortion policy should best be left to the lawmaking bodies and the people. The Mississippi case, along with a Texas ban on abortions after 6 weeks of pregnancy that is also pending before the Supreme Court, pushed the issue back to the forefront of the nation's culture wars. The oral arguments Wednesday drew thousands to the courthouse in Washington, including several members of Congress. Protesters spilled out onto the street between the High Court and the U.S. Capitol, shouting and waving signs proclaiming abortion is healthcare or life is a human right. Abortion rights advocates say allowing the state's 15-week ban to take effect would, in practice, overturn Roe by wiping away one of its central holdings that people have a right to an abortion until viability, the point when a fetus can survive outside the womb, or about 24 weeks into a pregnancy. The court's liberals, led by Associate Justices Stephen Breyer and Sonia Sotomayor, quizzed Mississippi's attorney on the implications of overturning one of the court's most widely recognized precedents. The Supreme Court should move cautiously with such a decision, they said, to avoid the appearance of politics. Anti-abortion groups argue Roe should be overturned because abortion isn't explicitly included as a right in the Constitution. The Roe decision and subsequent rulings haunt our country, Scott Stewart, Mississippi's Solicitor General, told the court. They have no basis in the Constitution, he said. Sotomayor shot back that the court has recognized many rights that aren't explicitly included in the text of the nation's founding document. There's so much that's not in the Constitution, she said, including the fact that we have the last word. Meanwhile, Biden reaffirms support for Roe and Wade as fate of landmark decision rests in Supreme Court. President Biden declined to say if he was concerned the Supreme Court would roll back abortion rights after oral arguments Wednesday indicated the court was likely to uphold a Mississippi law that bars abortion after 15 weeks. First of all, I didn't see any of the debate today, the presentation today, Biden told reporters at the White House, and I support Roe and Wade. I think it's a rational position to take, and I continue to support it, he said. The High Court's decision, likely to be handed down early next summer, will have ramifications beyond Mississippi. Dozens of conservative states are poised to approve similar bans. At least 17 states enacted trigger bans or have pre-Roe abortion bans in place in the event the Supreme Court overturns the landmark ruling, according to the Guttmacher Institute, a research group that supports abortion rights.